We have seen that Section 3 of the Charities Act 2006 removes any presumption that a purpose of a particular description is for the public benefit, but otherwise keeps public benefit as it is, public benefit being as the term is understood in the ordinary English law. Now clearly the question is, what does this actually achieve? What is this presumption of public benefit that is being removed? Well, there are a number of possibilities, and to be honest, it's not entirely clear what it does. The first possibility is this. There has always been a presumption of public benefit in relation to poverty, or even if not in relation to the other heads. And one possibility is that the section simply removes that presumption in respect of poverty, so that, for example, the poor relations cases are overruled, but that the Act has no other obvious effect. On the other hand, it has been said in certain contexts, as we have seen, that until now there has been a presumption of public benefit in relation to the first three heads of charity, not just in relation to poverty. This, however, is not as to the range of recipients of the benefit. This is as to the nature of the heads themselves, the scope of the heads. Religion, in other words, is assumed to be a good thing. Education is assumed to be a good thing, and there is no particular inquiry into its value. Now, another possible interpretation of the 2006 Act is that it removes any such presumption, so that the courts will in future be required to look more closely at the particulars of a religion or at the details of education before holding a purpose to be charitable under either of those two heads. It is reasonable to presume, I think, that the 2006 Act does nothing in respect of heads 4 and 5 at all. There has always been a requirement for public benefit in relation to heads 4 and 5, and there has been no presumption of public benefit. The existing law, therefore, must surely remain unchanged in respect at least of heads 4 and 5. As you know, in the press at the moment there is a debate about relaxing restrictions on access, for example, for independent schools. The problem currently being that the fees charged are at quite a high level, and sufficiently high to exclude quite a large section of the community. Now, the case law on public benefit is not really about restrictions on access at all. You may recall that Lord Simmons in Oppenheim talked about possible beneficiaries rather than actual beneficiaries, and the courts have tended to look at restrictions on possible rather than actual beneficiaries. Nonetheless, it may be that the 2006 Act is in response to recommendations of the Charity Commission, and the Charity Commission clearly are concerned with restrictions on access in the case of independent schools and indeed in the case of other educational purposes. It is at least arguable, therefore, I suppose, that Section 3 of the 2006 Act does have some bearing on restrictions of access and suggests that these should be relaxed. After all, if we now have to look at whether under Head 2 there is a benefit at all, there being no presumption that education is itself a benefit, then presumably questions of access could be a part of that.